Good morning or good afternoon, and thank you for joining us for today's webinar. I'm Kelly McIntosh, and today we're going to be discussing responding to noncompliance and repayments, which is the next in the series of Holland & Hart's Health Law Group's Health Law Basics, and the fourth in a series to start out the year. Before we get started, I'm going to just go over a few preliminaries and the roadmap of where we're headed today. We're going to be discussing compliance issues that can result in repayment obligations, the repayment requirements that have arisen under the Affordable Care Act and the current status of such obligations, the various means of making self-disclosure if that becomes necessary, both the Affordable Care Act proposed rule, the OIG Self-Disclosure Protocol, and the CMS Self-Referral Disclosure Protocol, which is related to the Stark Law. And I will note here, you'll see this throughout the presentation, but the ACA's proposed rule is a proposed rule, but it is in effect. So be mindful that actually all three of these are active and ongoing means to possibly make a self-disclosure. And then finally, we'll get into some practical suggestions for avoiding or responding to potential repayment issues if those arise. The written materials will be sent out to the entire group shortly after the presentation, and those will include all the slides. They will include the CMS proposed repayment rule, and that is the rule that's been promulgated under the Affordable Care Act, a copy of the OIG Self-Disclosure Protocol, open letters from the OIG which have modified or further added comment to the Self-Disclosure Protocol, and also the CMS Stark Self-Referral Disclosure Protocol. So you'll have all of those items that you can download. None of them are too lengthy, and then have those handy. Also throughout the presentation there are links and email addresses as appropriate, either to get further resources or to make self-disclosures to the necessary authorities. This presentation will also be recorded in full with the audio and the PowerPoint and available for download through our Health Law blog. And if you have questions, there is a chat function to use during the program. Depending on time, we may not have a chance to get to a Q&A time at the end, but feel free to still either submit questions via the chat line or email me directly, and I'll respond offline if we don't have time during the program. And if, while we're in the webinar, if you have any technical problems, feel free to email Luke Kelly, who will help resolve those. And again, if you drop off or miss any of the information, you can pull up the recorded presentation at a later time. And then just a few disclosures and disclaimers. This program is no review of legal issues and considerations. It's not giving legal advice, and doesn't establish an attorney-client relationship. Please always remember that you need to review applicable law, especially I'll note a few instances where you'll want to keep in mind to consider any state law overlay, and depending on where you're located, that obviously may be different than another participant or the federal requirements. So with those disclaimers in mind and roadmap, let's get into the program. Compliance issues arise and repayment obligations because if you want government funds through participation in government programs, you must comply with their conditions. And failure to comply with such conditions can result in either repayment obligations or additional penalties, which I'm sure as most of you are aware can be very significant, up to and including criminal penalties, fines, and exclusion from federal programs. Failure to comply with conditions for payment usually are things that would relate and could result in an overpayment. There's probably an indefinite and very lengthy list of all the things that could include. However, here's some of the most common or things that may come to mind when you think about things that would result in overpayment. Services aren't medically necessary, if they were not covered by the program to which they were billed, services not rendered, double billing or duplicate payments, unbundling, upcoding, not having necessary documentation, and the list goes on and on. There are a few key federal laws under which these obligations arise when there's an issue with billing or with overpayment. We have recently had health law webinars actually devoted to each of these specific laws, so I'm not going to go in depth into all these laws. Hopefully they're all names of laws and requirements with which you're familiar. If you'd like to know more in depth, I encourage you to look at some of our recent recordings that discuss each of these laws in depth and both how to comply and issues of non-compliance to watch out for. The first is the Anti-Kickback Statute, and this statute prohibits knowingly and willfully offering, paying, soliciting, or receiving remuneration to induce referrals for items or services covered by federal health care programs, unless you can fit into a regulatory exception or safe harbor. And remuneration in this context is very broad. It definitely can mean monetary amounts, but it can mean anything that is in receipt for a referral, which even can mean things like a referral, a promise for a referral, other types of value. It's a very broad meaning for what remuneration can include. And it also, in the Anti-Kickback Statute, applies to providers, referral sources, even beneficiaries. It can be apply and can have penalties attached to both sides of a referral transaction, so the person making the referral and the person receiving the referral. And of note, this statute is a criminal statute, which in part, well, which makes it intent-based, and there has to be some showing of intent, but I'd caution you that that has been held also quite broadly. So if even one purpose of the transaction is to induce referrals or for items covered by federal programs, it can implicate the Anti-Kickback Statute. So this one is definitely something that providers should, and anyone that deals with healthcare providers should be aware, because it does apply to anyone involved in a referral transaction. Penalties under the Anti-Kickback Statute can be up to and including the felony determination with a $25,000 fine and 5 years in prison, up to a $50,000 administrative penalty, and you could also be facing exclusion from federal programs. Anti-kickback violations are also deemed to be False Claims Act violations, which separately then attach specific monetary penalties up to $11,000 per false claim submitted. That's where up to 3 times or treble damages can be also imputed on top of the actual damage per claim calculation. And this is also where QTAM, or what are usually referred to as whistleblower lawsuits, can arise in terms of some whistleblower bringing to the government's attention potential violation of the Anti-Kickback Statute, and then those cases can develop into cases where the government joins in, or either does or does not join in, but can result in very significant penalties and findings of liability. The next law is the Ethics and Patient Referrals Act, which most commonly is known as the Stark Law. And this also relates to referrals, but it's a little bit different from the Anti-Kickback Statute in that this prohibits referrals by a physician or where the physician or a physician's family member has a financial relationship with an entity. And so this applies to physician referral relationships, not necessarily, or not all the relationships that would be covered by the Anti-Kickback Statute. And there are also a couple other key terms and designations here. It refers here to sending patient referrals for designated health services, which are payable by Medicare. And if there is a referral that would be prohibited under the statute, the entity cannot bill Medicare for any DHS improperly referred. Also, similar to the Anti-Kickback Statute, there are a number of regulatory exceptions, and referrals that would otherwise be prohibited because of a financial relationship are not prohibited so long as they fit within a regulatory exception. Unlike the Anti-Kickback Statute, this is a civil statute, and it's not intent-based. It's a strict liability statute, so if there's a violation, it's a violation whether known or not, and on top of that, compliance with an exception needs to strictly occur. You can't meet part of an exception. To claim an exception, you need to have full compliance with the applicable exception you're using. DHS, I won't get into all of these specifically, but this is a pretty expansive list of the types of services that are included in DHS. And then there are also a specific list of CPT codes that are issued each year and maintained on the CMS website. So if you're in doubt whether services are DHS and would implicate or need consideration under the Stark Law, I encourage you to check the CMS website. Penalties under the Stark Law include no payment for the designated health services during a period of disallowance, repayment obligations, and again, monetary penalties, which can be significant, especially when you consider that this is per improper referral. And again, also, Stark Law violations will also be maybe violations of the False Claims Act, so that again can get back into the treble damages, exclusion from federal programs, and additional per claim submitted penalties. And finally, the Civil Monetary Penalties Law prohibits a host of actions, including submitting claims if services were provided by an excluded provider or excluded person, inducements to beneficiaries, inducements to limit services, which is usually called or referred to as gain sharing, or failing to repay amounts when due. The Civil Monetary Penalties Law can be connected with anti-kickback or other violations of law, especially due to the repayment component, and penalties for civil monetary penalties law violations can be $10,000 to $50,000 depending on the conduct involved. Again, a treble damages potential and exclusion from federal programs. And again, as with the other laws, this can also implicate the False Claims Act, so any damages imputed under the Civil Monetary Penalties Law could be increased and then imposed with a per claim penalty as well. So those are the laws that you should be concerned about, and some of the conduct that could suggest issues that would then necessitate repayment. The 3 routes to making a repayment include the Affordable Care Act disclosure, which was promulgated under Section 6402 of the Affordable Care Act. This type of disclosure, which I'll get into in detail, may be less invasive than the other 2 means. However, it can't resolve civil or administrative liability for conduct that led to the overpayment, and may not be as final in that regard because disclosures under the ACA disclosure route may then lead to other governmental authorities investigating and separately imposing some penalty or finding obligation under other laws. The Stark Self-Referral Disclosure Program, and that can resolve liability for overpayment and underlying Stark Law violations. It provides more certainty in that it would resolve the self-referral and the Stark Law violations at issue, and the provider does have some involvement in determining or reaching a settlement or reaching a determination on what the amount that will be repaid entails. It will involve a penalty, however, so the ACA disclosure is much more writing a check to repay an amount determined to have been an overpayment. The self-referral and also the OIG Self-Disclosure Program are both programs that will involve a penalty. The OIG Self-Disclosure Program also, it can result in the release of civil monetary penalties and permissive exclusion authorities, so it would foreclose on those being potential outcomes for the specific conduct that's involved, not anything outside of that. Again, it would provide more certainty that any of the disclosed conduct is resolved and gives the provider some involvement in determining what that resolution looks like. The newest and first method of repayment I'm going to discuss is the ACA Repayment Law. And again, that was promulgated under the Affordable Care Act, though there had been other iterations of proposed or discussions of such a law in years preceding the ACA. This law talks about when a provider has received an overpayment, they must return their overpayment to the federal agency, state agency, intermediary, or carrier, and they must provide notification as to why they're making that overpayment. The overpayments must be reported and repaid within the later of either 60 days after the overpayment is identified or the date of that the corresponding cost report is due. And I'll note that the only items that could fall into the cost report timeline are items that could be reconciled on a cost report. So if it was a purely billing issue, that would be subject to the 60-day and wouldn't even have the cost report as an option out there. Things like expenses tied to graduate medical education, for instance, possibly would be cost report items that could be reconciled and then corrected on the cost reporting. So items that would tie to a cost report might have the date, it could be later than 60 days if a cost report is in connection. But again, even if both apply, it would be the later of whichever date that is, 60 days or the cost report date. As used in the repayment law, overpayment means funds a person receives or retains to which the person, after reconciliation, if applicable, is not entitled. So again, some of the things that might fall into that category would be non-covered services, duplicate payments, errors or non-reversible expenses in cost reports, and then significantly payments received that are in violation of STARK, Anti-Kickback Statute, or an exclusion statute. Do keep in mind, we'll talk about separate methods for disclosing under for STARK violations or anti-kickback violations, but those would be things that would be deemed an overpayment in the context of this law as well. There are some distinctions in what type of violation you're looking at. There are conditions of payment from government programs, and those require repayment. Those would be billing. It's a requirement of payment to correctly and accurately submit billings. It's a condition of payment to be in compliance or to not be in violation of the Anti-Kickback Statute, STARK law, or civil monetary penalties law. Then there are separately conditions of participation and other regulations that apply. Those don't necessarily require repayment. They should always be examined to make sure that the context in which a violation has occurred or the full scope of what that means in terms of repayment or what conditions might be violated. But things like the conditions of participation for certain types of providers and suppliers, conditions of coverage, licensure requirements, and some of the other federal laws like HIPAA and TALA and OSHA, violations or issues under those laws don't necessarily require repayment, but again, should be considered on a case-by-case basis. Another term that's used under the repayment law is regarding what it means to have a knowing failure to report and repay by the deadline. These take the same terms as used in some of the other laws, and then again have similar penalties to the False Claims Act and Civil Monetary Penalties law. So again, knowing failure can not only violate the repayment law, but also impose things like per violation and treble damages. Knowing means actual knowledge of the overpayment, acting in deliberate ignorance of the overpayment, or reckless disregard of the overpayment, and it does not require a specific intent to defraud. So the original conduct, giving rise to an overpayment, might not violate the False Claims Act or civil monetary penalties law, but if repayment is then not made and it was knowingly not made, those other laws can then be also imputed here. The proposed repayment rule came out in 2012, and it's actually still in proposed rule status. CMS has not issued a final rule, which is still expected to be forthcoming. But I would, as mentioned earlier, caution you that just because this is a proposed rule, in this case does not mean that this law and the rule are not in effect and are not being monitored and enforced by the government. The proposed repayment rule applies to Medicare Parts A and B, but other healthcare stakeholders and providers are still subject to the statute. One thing that's in the proposed repayment rule, and it's also found in the Stark Self-Disclosure Protocol, is the statement and the concept that the provider's initial decision of where to refer a matter involving noncompliance with program requirements needs to be made carefully. And I highlight that because as we keep continuing the different types of repayment processes that can be used, you'll see that some are more final, some have different pros and cons, some certain routes can only be used if you're talking about specific types of violations. So you may have a violation that in theory could be disclosed under any of the three repayment processes. So deciding which one is the most appropriate in the context of the facts that you have is very important. In the proposed repayment rule, to report and repay overpayments, providers are instructed to use existing voluntary refund processes. And those are found in detail in the Medicare Financial Management Manual, and they involve using forms and going through your Medicare Administrative Contractor, previously known as fiscal intermediaries. And each of such contractor has forms or portions of their website that will indicate how you can make a repayment. And so depending on which jurisdiction you're in and what type of provider, Part A or Part B, go to your applicable contractor's website and determine the form and process necessary. The report must include, and usually in all the forms I've seen, this information is also called out on the contractor's forms, but a repayment report must include the provider's information, how the error was discovered, the claim number or claim numbers that are tied to the repayment, what the provider has done in terms of corrective action to avoid repeat of such violation or overpayment, whether the provider is currently under a corporate integrity agreement or has already utilized the OIG's Self-Disclosure Protocol and is under that process, a reason for the overpayment, and that can include putting a statement like it was the incorrect service date, a wrong CPT code, a duplicate payment was received, some description of what caused the overpayment, the total amount at issue, and if a statistical sample is used in determining that there was an overpayment obligation, the method used to calculate that obligation. And very important, when submitting a repayment, a report of repayment to your contractor, you must include the amount that you're indicating must be refunded. So you need to send a check along with your report. It's not a report that then they will investigate and bill you. the provider needs to include the refund amount with their report. And again, the timing here is that the report and the corresponding repayment amount must be made within 60 days after the overpayment was identified or the cost reporting date. The overpayment is identified, and this is one of the items that may be clarified in the final rule, but the term identified has been deemed to mean if there's actual knowledge of or existence of overpayment, or if a provider acts in reckless disregard or deliberate ignorance of an issue being out there. It's not necessarily that the provider has determined the amount of repayment. So if a provider sees that or determines that there has been an overpayment and still needs to go through the calculation process of reaching the dollars and cents amount of what that overpayment totaled, that doesn't, the identification process does not necessarily attach when the dollar amount is reached. It attaches when the provider learns or determines that there has been an overpayment. And as I mentioned, this is an open issue that it has already arisen in certain cases and is one item that commentators think may be addressed further in the final rule. If you have, or if a provider has noted a potential overpayment notice, they must make reasonable inquiry and use all deliberate speed to determine whether an overpayment exists. And that gets in part to the acting in reckless disregard or deliberate ignorance. If, for instance, a compliance hotline receives a call that gives information that would suggest it could result in a finding of an overpayment, there's an obligation to make reasonable inquiry and to do that with all deliberate speed to fit within the time frames required for repayment and also to determine if an overpayment occurred. Here's some examples of identified overpayments. So determining your erroneous codes were used after review of records, determining services were rendered by excluded persons or unlicensed persons, again, a compliant hotline tip points to potential overpayment. And again, the term identified seems to mean when the overpayment is confirmed or there was notice and failure then to make the reasonable and speedy inquiry thereafter. There's no minimum threshold amount for the repayment rule, and one thing that's not clear at this time is how this rule works with other existing processes, because there are certain processes that providers use currently if a billing issue has arisen where they may rebill the amount or address a credit balance. How those interact with the repayment rule has not been spelled out. It could be forthcoming in the final rule and might provide some more clarity in that regard. Another thing that's open is what the look-back period for the repayment rule means. CMS can reopen claims within a year for any reason, within 4 years if they have good cause, and any time due to fraud or fault. The False Claims Act has a statute of limitations of 6 to 10 years, depending on the conduct. So the look-back period has been guessed to be somewhere, or it has been applied, and people dealing with this rule thus far have been typically operating under the 6 to 10 year type threshold, but final guidance on that also may be forthcoming in the final rule, which would spell out more clearly how far back a provider needs to look in calculating repayment obligations. The proposed rule said 10 years, but since then there's been discussion on that, as I mentioned, and the final rule would hopefully finalize that either at 10 years, at 6 years, or identify what type of different conduct would apply to different time frames. There can be options to extend repayment timing and making the full repayment amount. It's not automatic, but if that's an issue, if you find yourself in a situation where you need to make a repayment and can't make the full amount when you submit your report, there is the extended repayment schedule process, and if that's something you need to consider, the Financial Management Manual also includes details on that process. Again, this rule will not give the certainty that the other disclosure protocols would give, in that it doesn't resolve any other violations or penalties. It just handles the amount of overpayment and getting that repaid to the federal program. So if there were separately issues that the repayment was owed due to issues under the Anti-Kickback Statute, Stark, the Monetary Penalties Law, just making the repayment and reporting that to the contractor would not resolve any of those other amounts. And beyond that, once a report is made to a Medicare contractor, if the contractor, in considering the repayment, determines or believes that that might have involved a violation of another federal law, then they may report that payment to the OIG, CMS, or other federal agencies. So that again goes to both being careful on what you disclose, careful choice of which process you use to make a disclosure and repayment, and then just understanding that the information you share with one government entity may get to other entities and lead to an investigation of other activities. And so again, that's where you'd want to consider which disclosure protocol is most appropriate. And under both of the OIG or Stark self-disclosure protocols, if you choose one of those two routes, it would suspend the time of making the repayment under this law. As I'll note, you don't send a check along when you self-disclose under the Stark or OIG protocol, and if you use one of those avenues, you don't need to separately send your payment back to the contractor under this repayment rule. The time would be suspended until the resolution of the other process that you're utilizing. So here's some open issues again from the proposed rule. What the definition of identification of overpayment really means. Some argue that actually having no definition allows to then make your case on a circumstance by circumstance basis, and potentially that having a strict and firm definition of identification might put providers in a more of a box than they otherwise would find themselves in. But that is likely something that would be in the final rule. Again, the length of the look-back period and finalizing what that means, and the interplay of other processes that are available to deal with billing or some of the payment issues at this time. The proposed rule is now the industry standard, so just because this is proposed, again, don't think that it's on the shelf and not being used. CMS has made it clear that this is the 60-day rule is self-implementing, and it's a reality even without the final rule. One of the cases that I'll be watching this year, and I think a lot of healthcare providers will be watching in regard to repayments, is the Health First case, and this actually it's an ongoing case that arose last year. It was a whistleblower case and involved about 900 claims that by a hospital that may have been erroneously submitted. An employee identified those claims in February of 2011 to the hospital. The employee was subsequently terminated, and the hospital then allegedly did not make the repayment until March 2013 after it received a civil investigative demand. So it did ultimately make the repayment, but the DOJ, the Department of Justice, actually intervened in this case, alleging that the defendants here failed to return the payments in the 60-day time period under the ACA. So what the hospital here has argued, and one of the things that kind of goes to that what it means to have identified overpayments, is if a provider has just discovered that there are some suspect records, is that enough to equal identifying overpayments, or does that attach at some later point when more information has been learned that would actually get to what the overpayments include or what that obligation is? So again, this is ongoing, and without the final rule coming out, a case like this or others that may arise may give some further guidance in practice as to what it means to have identified an overpayment. And the next route of self-disclosure and repayment, or potential repayment, is the OIG Self-Disclosure Protocol. This is a voluntary program, and some of the benefits to using this route of self-disclosure are that the OIG might reduce penalties if a provider fully discloses and cooperates. Often going this route means that a provider won't ultimately have a corporate integrity agreement versus if the OIG starts investigating independently and then comes to a settlement on an issue that was not self-disclosed. Corporate integrity agreements often are imposed on the provider. This can help, making a self-disclosure can help cut off whistleblower and key TAM type lawsuits. If the conduct has been out there and self-disclosed, then it can help preclude a whistleblower bringing that same conduct to light. And as I mentioned, it suspends actually having to cut the check and making repayment under the proposed repayment rule while this process is ongoing. There are a host of risks here, though. There's no guarantee that the OIG will reduce any penalties. Penalties under OIG settlements and resolutions are often very significant and can be devastating to providers. The OIG may broaden their investigation beyond what is disclosed and find other conduct that either was not yet discovered or was not disclosed by a provider that has other violation implications. And those, anything discovered outside would be outside of this protocol, so they wouldn't be afforded some of the same benefits that were just discussed about items that are self-disclosed. If a provider starts in this protocol but then does not fully disclose or is not fully cooperative, they can either be kicked out of the protocol and this process, or also can be subject to additional penalties. The OIG may share information they find with other governmental agencies that might have separate actions against a provider. And then one of the things that is pretty clear, well, in most resolutions with the OIG, the settlements or the documents that are final in how these items are resolved are public, including the names and identifying information of the provider at issue. This protocol should only be used to resolve matters that potentially violate federal criminal or civil or administrative laws. So if you're only talking about matters involving overpayments or errors, then this would not be the route that you would go under. And usually it would apply to violations that involve actual knowledge, reckless disregard, or deliberate ignorance. So kind of a higher threshold in most cases. Not usually covering honest mistakes or errors. This would not be used to report or address stark violations. And this can be used even if the disclosing party is already subject of a government inquiry, but you need to make sure that if that were to be the circumstance you found yourself in, that any disclosure that needs to be done in good faith and not in an intent to circumvent the ongoing inquiry. The OIG has a website that has a host of information on its self-disclosure protocol and information, and actually is a route where you can go right ahead and make a self-disclosure under this protocol. So I'd encourage you to check that out or bookmark it as something that's updated from time to time and a handy resource. This process involves either, if you discover ongoing fraud, making contact with the OIG immediately, or conducting your initial investigation to confirm that this would be a protocol that would apply and would be the proper process to follow. Written disclosure to the OIG must be provided, and that includes all the provider information, a description of the conduct disclosed, a description of either the investigation that's been completed or when that is estimated to be completed and the stage of the investigation at this point, the estimate of damages and how that estimate was calculated, whether the provider is already under investigation by the OIG or other government agency, what laws are potentially violated, and this must be specific. You can't try and throw in any violation that may be out there by using general statements about possible violation of just federal laws, rules, and regulations. You need to identify with specificity that it's the Anti-Kickback Statute or even what portion of that statute with as much detail as possible. And there must be an acknowledgement that conduct is a partial violation, at least, so there is some affirmative violation acknowledgement required here. And you also must indicate who, on behalf of the provider, could enter into a settlement with the OIG, and then certification that the information provided is true, and a person able to make that certification on behalf of the entity is required. Again, the disclosures can be submitted directly through the OIG's website. They can also be submitted in hard copy, and you can't fax the submission at this time. If you are dealing with this disclosure protocol and you have a specific, I would suggest you pull the whole protocol if this is one that you're considering making your disclosure under, and again, that'll be included in the materials. But if you're dealing with a disclosure regarding an excluded person or false billing, the protocol also includes specific items, sub-items, more than just this general information that must be included in regard to certain types of conduct that you're disclosing. So again, this process would involve an internal investigation, and that has to happen within 3 months. You need to let the OIG know what the response and discovery to the matter has been, the self-assessment of the impact on federal programs. Once the OIG receives your report, they'll verify the information in the provider's report, and they are entitled to access to all audit and other papers without regard to any privilege which could otherwise attach. It's very important, again, that if you're in this protocol that you continue to cooperate and timely work with the OIG. Cooperation is a central piece of this protocol and can result in either losing the benefit of being in this process or separate penalties for not being cooperative or giving complete information. You don't make payments while this process is underway without OIG approval. So again, you wouldn't make any payment back to your contractor or to anyone else while you're in this protocol. The OIG does encourage providers, though, to place, if you think you have a number or an estimate of what the amount is, and that amount must have been included in your report. So whatever that amount is, the providers are encouraged to place that money in an interest-bearing escrow account while the process is ongoing. This is a statement from the Federal Register with this protocol, and it gets to the fact that, again, if a provider is not working in good faith and cooperating, then that can actually be an aggravating factor considered when the OIG assesses appropriate sanctions and resolutions. So that act in and of itself could result in separate criminal or civil sanctions, and you can be expelled from the process. The OIG has modified or provided additional comment to its protocol on occasion. They've issued a few open letters. Those are also going to be sent right in the materials. And then the most recent update, they completely restated the protocol in 2013. And some of those updates have made changes to the minimum settlement amounts and also clarified things such as that stark disclosures can't be made under this protocol. If you determine that the OIG Self-Disclosure Protocol is the appropriate route to use in your circumstance, don't assume that you will avoid all penalties. There are also, as I mentioned, certain either formulas or routes that the OIG seems to have taken and takes from time to time on certain types of claims, and there's certain information that they require be provided for certain types of conduct that's being disclosed. Under the False Claims Act, if you disclose within 30 days, your penalty potential is reduced from treble damages, which is 3 times damages, down to just 2 times damages. So speed, even short of the 60 days, getting in under 30 days can be very important here. Last year, there was a recovery of over $23 million under the OIG Self-Disclosure Protocol, and a couple of those disclosures and resolutions, a hospital's operation of an ASC and related potential anti-kickback violations resulted in a $1 million settlement, and a home health provider that billed hospice services without required certification documents resulted in a $2 million settlement. And when we get to the Stark Law disclosure resolutions in a minute or two, you'll notice that these settlement amounts under the OIG Self-Disclosure Protocol are significantly higher than most of the resolutions under the Stark Law Protocol. So the resolutions and settlements, when you find yourself under this process, are still likely to be very significant and could be devastating on a provider. And then the third disclosure protocol is the Stark Self-Disclosure Protocol. Again, it's a voluntary program, can help reduce penalties. It might help preclude whistleblower lawsuits. It also suspends repayment under the repayment rule, and it may maintain more confidentiality versus the OIG's protocol. Stark protocol resolutions are not disclosed in the same level of detail. The type of provider is disclosed, but names are not put on the CMS website. Rather, it'll say a hospital in Michigan resolved potential Stark Law violations for X amount. So it keeps a little bit more confidentiality, or has the ability to. If an issue relates to both potential Stark violations and violations that could be disclosed under the OIG's protocol, they cannot be reported under both, and they should be reported under the OIG's protocol. So again, that would be important to keep in mind if you're trying to determine which protocol to utilize. Some of the risks are similar here as to the OIG protocol. There's no guarantee that penalty reduction will occur. CMS can always broaden its investigation if it finds other information. Failure to disclose or cooperate can kick you out of this, can result in you being kicked out of this process, and also have additional separate penalties. CMS may report concerns to other government agencies. Again, things like waiver of certain privilege and public information are also potential out there. Use this protocol when you have confirmed or it's very likely that a Stark violation has occurred, and assume that there is going to be some payment. If you're trying to get guidance from CMS on if a course of action or if an arrangement is a Stark violation, do not self-disclose under this protocol. There are alternative processes like requesting and obtaining an advisory opinion, or looking to the Stark frequently asked questions that can give guidance on arrangements, but would not be making affirmative statements that a violation has or is likely to have occurred. Under this protocol, you must disclose within 60 days after the repayment is identified, and you must repay within 60 days after receipt of payment pursuant to improper referral, or you would be subject to a $15,000 penalty per claim submitted. And this, though, suspends the repayment obligation of the Repayment Law, so that 60-day repayment here is handled separately and would be handled through this settlement process dealing with CMS versus your Medicare contractor. So if you're under this protocol, again, don't cut a check to your contractor in repayment while this is ongoing, but instead work directly with CMS. CMS also has a website on its disclosure protocol that has a lot of helpful information and is also updated from time to time. This process, again, entails electronic submission, can be done either with initial disclosure through electronic submission to a CMS website or a hard copy submission to CMS. You do have to mail a copy of the signed certification in any event, and there's currently significant backlog of self-disclosure protocol disclosures and then response. So if this becomes something that's necessary, it may be a significant process before CMS actually engages in, you'll get word back that your disclosure has been received, but it may be a significant amount of time before the process of investigating and resolving that with CMS occurs. Required information here includes provider information, why and what the potential violation was, what actions were taken to address the disclosed matter, if there's any history of similar conduct or current investigation ongoing, description of the provider's compliance program, and if any other notices to government agencies have already been made, for instance, if a notice or some sort of correspondence with the IRS or other agencies that might have implication has already been made. The financial analysis of the total amount by year and the methodology used to get to that amount, and then a certification. CMS can refer these initial disclosures to the OIG or DOJ, so as with all of these disclosures, they should be carefully drafted because disclosure to one agency can get to other federal agencies. Under this protocol, the repayment's limited to a 4-year look-back period, and this just gets to some of the steps on how to determine the time frame and then calculate the repayment amount required for disclosure. CMS will then verify what's in the report, must have access to all of the information. It can request additional information, and there are set time frames in which to respond, and anything that's discovered outside of what's disclosed would be treated as can be treated as new matters outside of the disclosure process. Again, don't make payments while you're under this protocol without CMS approval. Again, encourage to place the money that is asserted to be in the disclosure as the amount at issue in interest-bearing escrow account, and then the payment also must be made to individuals who are improperly billed for services of improper referrals under this protocol. Here again, similar to the language in the OIG protocol, failure to cooperate and act in good faith can remove you from this process and also subject you to separate criminal and civil sanctions. Some of the factors CMS would consider in determining if they're going to reduce amounts owed under this protocol are the nature and extent of the improper or illegal practice, how timely self-disclosure was made, cooperation by the disclosing party, the litigation risk associated, and also the financial position of the disclosing party. But again, there's no promise or guarantee of any reduction. Settling, after considering factors, CMS will determine a settlement amount. Often that can involve some negotiation, but don't bet on it or don't plan that there will necessarily be a negotiation process. You might be able to enter a long-term payment plan. However, even if the amount reached is not open for negotiation, the terms of paying that back may be open to some discussion. And settlement under this protocol does not relieve the party of any other potential violations except those related to Stark. And you can withdraw if you don't accept the settlement here. And so here again, just a few examples of CMS summaries of recent settlements, and this is in contrast to some of the high numbers in the OIG settlement amounts in November and December of 2014. So these are just very recent. Hospitals, physician group, all reached settlements under this protocol, and the amounts for their settlements were as low as $60,000 up to $231,000. But again, some of those amounts would not necessarily be as crippling to a provider as amounts that are often reached under the OIG disclosure protocol. You can also always report to the Department of Justice. It's not a separate disclosure protocol, but you can contact the DOJ or your local U.S. Attorney's Office. The DOJ has authority to settle most claims, and will often work with providers. However, DOJ is in the business of prosecuting, and there is no defined process. So again, trying to navigate these waters very carefully is important. And remember your state laws. There are usually state versions of the fraud and abuse laws, and many states have their own report and repair requirements. So be aware if you are considering a disclosure under federal law, there may very well be something that's also due under state law. It's definitely better to comply and not find yourself in the circumstance. Ways to do that are to understand the applicable fraud and abuse statutes. All of these laws in general, as I mentioned, we've just recently done webinars on all of them if you need a refresher. The OIG work plan, which is issued each year, I find also to be very helpful because it indicates areas that the OIG is specifically looking at or has on its radar. The OIG also has several resource materials available to help you either ensure your compliance, get a compliance plan going, or again, understand areas of concern. Implementing an effective compliance program is one way both to hopefully prevent this conduct from arising, but also to identify any problematic conduct or as early as possible. So if you have a repayment obligation or you have something that would get to the STARK or OIG Self-Disclosure Protocol, trying to find that as soon as possible obviously would help mitigate then the hit that a practice or provider may take from that problem. But one big caveat to remember is that having a compliance plan that you're not implementing, that just sits on the shelf or isn't used, or not responding to identified issues once they arise is as bad or could even separately have certain claims and be worse than having no plan. So have a compliance plan. They're definitely required and or recommended and going to be required soon, and also then put it into action. Definitely check in from time to time with your financial relationship and physician agreements to make sure that you consider them under the STARK and Anti-Kickback Statute. Consider and document all the things that go into complying with exceptions there or making sure that they're not problematic. Again, things like just one purpose of a relationship being to generate referrals can be enough to trigger anti-kickback issues. So keep things like that in mind, or if circumstances have changed since the agreement was entered into. If you find yourself with a problem, definitely one of the first things is to stop billing, stop submitting the claims that are related to that problem until the situation's resolved. So once you submitting the claim with knowledge of a problem can trigger things like the False Claims Act or STARK or Anti-Kickback or Civil Monetary Penalties Law. Assess the scope of the problem. Definitely consider involving knowledgeable healthcare counsel, both to help you evaluate the underlying issue, potentially have some privilege and protection, and to help determine if repayment or disclosure is needed, what processes is most appropriate. And the clock, remember, the clock is running once you find noncompliance. So immediately investigate. The acting with all deliberate speed is important. Gather and review your relevant documents, conduct interviews, document everything throughout the process. And assume whatever you document, though, will be discovered or will need to be produced if you then need to go into one of the disclosure protocols. Never destroy relevant documents or falsify information. Again, those types of actions can separately have criminal implications outside of any underlying violation. And never retaliate against whistleblowers. That can separately lead to penalties and also it could lead to being kicked out of the protocol processes. It can have significant implications. Determine if a violation actually occurred, and see if you can satisfy a safe harbor exception where possible. Look to the regulations that were relevant and applicable at the time in question. Sometimes things change and the status of a law now may not be what was actually the one applicable at the time a claim was submitted or something occurred. Look to other sources as well, advisory opinions, CMS frequently asked questions. There's lots of resources out there that can help give commentary on relevant compliance issues. There are potential exceptions for providers without fault. However, this is definitely limited, and you need to make sure that reasonable care and some of these specific things all would apply. And if a problem exists, fix it. Don't turn your head the other way. Modify your processes, discipline employees, terminate or revise agreements. If there's a Stark issue, consider the repayment to end the period of non-payment, or required repayment to end the period of non-compliance. Fixing it is definitely a recommended course of action. One, because it stops the time period. It also evidences the actions taken to address the problem, but fixing a problem doesn't resolve the past problem or end the repayment obligations. So it's a recommended step, but doesn't mean that no repayment or other process would be necessary. Update your trainings and processes, document your remedial actions, and then all those actions that you take internally to respond to a problem, include those in your disclosures. Those will be helpful to any agency. Again, confirm your payment obligation depending on which route you're going into, and make payment if needed under the Repayment Law, or use the Stark or OIG disclosure protocol if necessary. And once you move to self-report, though, remember that you don't turn back from that. So don't take it lightly, but also move quickly under the time frames required to make a determination. Again, just can't highlight enough, once you're in one of those processes, well, cooperate, cooperate, cooperate. Be truthful. Do not withhold information. Make your best case, but do that with all the information needed so that there aren't separate actions possible. Be very careful in calculating any repayment obligations, and consider the applicable look-back period. Your obligation is likely to be cut off at a certain point. Different methodologies apply to different processes. So again, when calculating your repayment, look to the specific protocol or process you're finding yourself under. Always document the final resolution with the government, and keep in mind that resolving on one protocol does not necessarily resolve issues with all government agencies. So for some additional resources that will help in that process, the OIG has also a good fraud and abuse website that has some compliance training and is where they post then advisory alerts and, fraud alerts and advisory opinions and special advisory bulletins. They have lots of compliance program guidance. There's guidance for hospitals, physician practices, other types of providers So definitely I encourage you to go on that website and check out the compliance guidance that's applicable to your provider type. Lots of information material is available on the internet, just with a big caution sign of there's a lot of either information that's out of date or just bad information. So keep in mind the source and timing of what you're looking at on the internet. We at Holland & Hart have some other resources on the Health Law blog. We have our past webinars. We have publications with client alerts. And also feel free to email me with any questions. Our upcoming webinars are going to be on HIPAA, electronic medical records, and tax issues for healthcare entities. So I hope you'll also join us for those. We're a few minutes over, but thanks for joining me today, and I hope that you'll join us on a future webinar. Thanks, and have a nice afternoon.